All right, welcome everybody. This is our third webinar in a series for the California Psychedelic Bar Association. I should note that it's being recorded and it will be posted on YouTube and once we figure it out, podcast apps. I'm Paul Slattery, one of the two co-founders of the California Psychedelic Bar Association. When I'm not doing this, I am the general counsel of Eleusis, which is a psychedelic pharmaceutical company. My co-founder, Rebecca Lee, can't make it today. She is the general counsel of Journey Collab. And rather obviously the clever one between the two of us, so I'm unsupervised here. We'll see how it goes. Our previous two webinars were with Professor David Nichols and Professor Charles Nichols, which you can find on our YouTube channel. They laid the foundation of the science and research efforts in psychedelics before we turned to more strictly law and regulation. But we're, after all, a bar association, so it's time to start getting into the actual law and regulation of psychedelics, which has to begin with the Controlled Substances Act. We're very happy today to have Matt Zorn, who is a partner at Coleman. I should note that we did meet in a professional capacity, particularly around the DEA's attempts to schedule some additional psychedelic substances, though we don't work together all the time. Hi, Matt. How are you?
Hi, Paul. Doing well. Thank you for inviting me on here. It's a pleasure to speak a little bit about what I'm doing, especially since some of it's a little bit away from public view. So thank you for inviting me.
We're very happy to have you. So you have a long resume, and I may call out a few parts of it as we're having the conversation, but it'd be sort of boring for me to sit here and rattle off a summary. I thought it would be more interesting for you to tell the story. So can you sort of take a few minutes and walk us through your career path? And if you do an insufficient job bragging about your cannabis and psychedelic law experience, I'll force you to do it. So you might as well.
No, actually, why don't I start there? Certainly anyone can go look up my bio on my firm website at yettercoleman.com. So why don't I just kind of start with, well, how do I get into psychedelics? It's actually an interesting story. Basically, I went to Columbia Law School in New York, and in 2010, I took a seminar called Drugs, Law, and Policy. And it was my second year of law school. And at this exact moment in time, I believe this is when the MAPS MDMA phase 2A clinical trials were coming out. And so as a seminar paper, I kind of dug into the Grinspoon debacle back, the Grinspoon versus the DEA debacle back in the 80s with MDMA and it getting scheduled, and kind of how it got scheduled and briefly came off, then went back on. So I dug into the legal issues there, wrote a seminar paper, and then I was just hooked, and I just kind of dug in, read all what I would call sort of the classic psychedelic literature. And I don't mean classic psychedelics. I mean like the books that, starting from Doors of Perception all the way, before Michael Pollan published the New York Times bestseller, and I read through all of those and whatnot. And then I did what any good Columbia Law School graduate did, and went into big law and didn't do anything with any of this stuff, and just kind of tabled the whole thing. This was right after the mortgage collapse. Did a little bit of, the 2008 mortgage crisis. Did a little bit of securities law at Paul Weiss, and I loved my time there. If you're going to go to big law, it was a great place to be. And then, while I was there, I experienced kind of a personal tragedy. Hit really close to home. And long story short, after that kind of situation cleared up, I left New York and came to Texas to clerk. Well, I clerked in the Eastern District of Texas. It's one of the top patent dockets, and at the time it was the top. I think we had over 2,000 pending cases when I clerked there, almost all of which were IP patent cases. I had gotten into IP law, Paul Weiss. I had transitioned away from the securities into patent litigation. By the time I had applied to the Eastern District, I was a pretty well-versed patent litigator. And that's how I get to Texas, which is kind of the next link in the story, because I end up here at where I'm at now at Coleman because I liked it in Texas, so I stayed. And I went to South by Southwest in 2019 just because I wanted to. And I listened to a presentation by Dr. Sue Sisley. And this is March of 2019. And she's discussing how she was applying to grow her own cannabis for research, and her application was being held up at the DEA. She had heard nothing for 2.5 years, not even an acknowledgement of receipt. And so, based on the personal experience I described from New York, the sort of the tragedy that I experienced, and then kind of even going back farther, like I said, like I had sort of built a legal foundation. Like I understood enough about the Controlled Substances Act where I was like, I was just interested in it. And that kind of just, so I filed that case, a mandamus case in the DC Circuit, ultimately resulting in changing federal policy on cannabis research. And then one thing has led to another. And, here I am now known as the guy who sues the DEA.
Got it. So at present, I don't have a sense that there's much litigation in psychedelics outside of challenges to DEA scheduling efforts. Am I right about that? And if I am, where do you see litigation in psychedelics starting up sort of as the field matures? I imagine the answer is first IP, given the flurry of patent filings. I'm curious your thoughts.
I think you're correct. I don't think I don't think there is psychedelic litigation. Certainly there's not commercial litigation. There is this kind of regulatory litigation that I'm doing right now. There's patent prosecution work. And I'm sure you're familiar with that. But there's no litigation. I think that, there is kind of the Compass IP wars are kind of hitting up at the patent office with the IPRs. That's like quasi litigation. So I agree with you. The next IP is probably the next frontier. I don't know if it's necessarily patent enforcement litigation, but there's certainly kind of adversarial private disputes. I think we'll probably see some contract stuff too. I imagine maybe not with the big players, but I imagine, I don't like comparing cannabis to psychedelics. I think there's fundamentally different aspects to them that make them kind of unlike, and you can't use one to project the other. But in cannabis, there are commercial disputes involving financing, and especially like with smaller companies and whatnot. And I imagine with psychedelic, anytime you have any amount of commercial activity, there's always going to be some partnership dispute somewhere. So I imagine we're, not too far along from that.
So I'll actually jump ahead there in the questions, given you raised it. There seems to be, you've done some work in cannabis, and that seems to have in part segued to your work in psychedelics. There's a temptation, I think, for folks to look at cannabis, look at psychedelics, and say, oh, psychedelics are just sort of delayed from cannabis, but on the same path. And so you can use the two as an analogy and expect them to wind up with, for example, the same sort of, dynamic of federal state being problematic. That analogy is actually a thorn in my side. When you do things like go and buy D&O insurance as a general counsel, and you say you're in psychedelics, they'll go, "Oh, you should talk. We'll bring in our cannabis group guys." And no, we're not operating in a gray area. We have affirmative permission from the FDA, DEA. It's different. So could you talk a little bit about why you don't like comparing the two, what might be analogous, and sort of what's not? I mean, it seems to me, at least from the psychedelic perspective, pharma is kind of leading the charge here, which is very different from the cannabis experience, but people do seem to tie the two.
Yeah, no, it's a great question. And maybe I start off by saying kind of where they are in common, like how do I end up in both of them? In other words, if they're not in common, why am I doing both of them? I think there's a common thread with the Federal Controlled Substances Act and the regulatory, like at the highest sort of most abstract level, right? They're both, cannabis is in Schedule 1, so are psychedelics. So you're dealing in some respects with the DEA in both regards. It starts to fall apart when you kind of push past that. Maybe like filing for a cannabis patents and like a psilocybin patent they're similar, but that's not because they're like similar, except like a chemistry patent is similar to a chemistry patent. So it's not cannabis and psychedelics so much as it's just like you're applying for like a molecule patent or whatnot. So the reason I don't like to compare them, why don't I hit on what I think is the major issue, and it's a very, I don't want to say it's very underappreciated because I've talked about it enough now, but it's underappreciated, which is the paradigm that the status quo for cannabis that we have now is never going to work with psychedelics, right? Cannabis is built around this principle of non-enforcement. And the reason how we get there has to do with the California and the 1996 law The federal government came back and tried to stamp it out. And then the case Coleman versus Walters comes along and says, you know, the federal government can't forbid doctors from recommending cannabis to patients. And the effect of that wasn't that doctors were ever writing scripts for cannabis. They still don't. But what happened was it enabled this entire not cottage, but an entire industry of dispensaries to come up, which were not run by the medical profession. This is the key difference, right? So there's a separation of medicine and dispensaries and cannabis, which has been allowed to proliferate and frankly, across the states. And that's the framework we have. This is never going to work with psychedelics because psychedelic medicine is not based on the principle that you can go down to a dispensary and even the Oregon law that was just passed is not based on like the cannabis model, right? I mean, it's not completely like, so if you're not dealing with that and you're dealing with a situation where medical professionals really should be involved, you're dealing with a situation where medical professionals aren't going to be putting their licenses at risk, right? See, that's the whole thing about the cannabis situation. The doctors aren't putting their licenses at risk because of the Coleman versus Walters case, the First Amendment, and the idea that they're just recommending. The moment you go past the recommending phase, you're aiding and abetting a Controlled Substances Act violation, and you run into all sorts of problems. So the psychedelic, it's on a fundamentally different track, which is, again, the FDA approval track, right? The cannabis situation, you know, you don't have to go, like, there's never been this urgent need to go the FDA approval path because the medical profession could always be one step removed. That's not going to work with psychedelics. And so it's all going to have to go through the FDA approval process. Once you start from that base, you're dealing with all sorts of different economic and legal problems, including the need to get patents, right? Cannabis companies really don't need IP to be successful. Or if they do, we're not talking patents, right? We're talking like branding and whatnot. You know, I'm not saying psychedelics companies require patents to be successful. I think that's a misnomer. But the fact of the matter is, if you're not doing the classic psychedelics and you're trying to convince investors, hey, I got this new molecule, it's worth investing in it, you're going to have some sort of IP, something. And that's a little different from cannabis, where, you know, maybe the best IP you could have is maybe Mike Tyson promoting your product or something. You know, so it's just we're dealing with totally different animals. And I think personally, and I'm not saying there aren't other arguments about differences, but I think personally it goes back to that basic thing that I don't want to call it the Coleman versus Walters idea, but the idea that the medical profession actually can function separately from the medicine that's being distributed. Once you get rid of that, everything falls apart.
That makes sense. So let's take a bit here. This is sort of one of the goals for the webinar, and lay the foundation of the Controlled Substances Act. You know, some folks watching won't be that familiar with it. It was introduced to you by a seminar and all that. So just really simple question. Can you give us an overview of sort of what the Act basically does and its structure?
Yeah, I mean, so the Controlled Substances Act, it is a little misunderstood, but the objective in 1970, when it was enacted by Congress, was to make sense of drug laws, which sounds bizarre today because everyone thinks it makes no sense, and it doesn't make any sense. But the goal was, there were basically a bunch of disparate laws on the books for different substances. I mean, there was a narcotic, like for opiates, marijuana was treated separately. LSD was controlled under, I think it was a 1965 law. And it was a hodgepodge of laws that have different enforcement mechanisms among Treasury, Department of Justice, and whatnot. And the Controlled Substances Act was this attempt to create this unified framework based on the schedules. And the idea was we could apply this to all drugs of dangerous abuse, and we would rank the drugs Schedule 1. Well, this is another misnomer. Schedule 1 is not for the most dangerous drugs. It's just for drugs that had a high potential for abuse and also no accepted medical use. And then 2 through 5 was ranked in order of danger. And this was this like unified paradigm that was created in 1970. And again, contrary to what intuition said, the idea actually was the thing was supposed to be flexible. The idea was that the legislation was too cumbersome of a process, and the at that time it was called BNDD, the Bureau of Narcotics and Dangerous Drugs, wanted flexibility to be able to move things up and down, like up and down as they wanted to. But and I think there's a good law review article by Mason Marks in 2018. It's probably the best law review article that's ever been written on this stuff, and it's quite good. And basically, I think he cites another scholar, but the Nixon administration basically hijacked the bill or the act once it had passed, and everything now kind of unidirectionally went up. We had the war on drugs, and it's been so long since it was originally passed that all of the way it's been implemented has basically, like, now the way we think about the Controlled Substances Act is kind of different from what it was intended to do. But that's, Schedule 1 has basically been a one-way street. I think there have been 2 drugs which have been removed out of Schedule 1 in the past 50 years. So
that's helpful. And I think you touched on it a bit, but there are actually 5 schedules and the standards for Schedule 1. Could you go over those again and then just talk a little bit about the standards for the other schedules so people understand?
Sure. Yeah. So there are 5 schedules. There's Schedule 1, and then there's Schedule 2 through 5. And Schedule 1 is for drugs that have a high potential for abuse, is the first factor. The second is no currently accepted medical use and treatment in the United States. And the third is a lack of accepted safety for use. And the statute is 21 USC 812. And I want to say something, remind me to get back to that Schedule 1 in a moment, but let me go through the other schedules. So Schedule 2 is high potential for abuse. The second factor is currently accepted medical use and treatment in the United States, or currently accepted medical use with severe restrictions. And then 3, I think, is a high likelihood for psychological or physical dependence, or it's the most extreme sort of physical and psychological effects. And then I don't need to go through the others, but basically 3, 4, and 5 are just kind of like descending in terms of like milder and milder based on 2. So you have this, 1 is where all the drugs that have no accepted medical use and high potential for abuse went, which was heroin, LSD, marijuana as well. 2 through 5 are sort of the balance of your drugs, with the more dangerous ones like cocaine, which has an accepted medical use, methamphetamine has a approved indication for narcolepsy. Interestingly, PCP is in Schedule 2 because at one point it was a veterinary anesthetic. And then you go down to Schedule 5. There are actually exceptions to this. I mean, there are drugs in certain non-Schedule 1 categories which have no accepted medical use. I don't know, an example would be ergine. It's in Schedule 3. I don't think it's ever been approved for anything. So, I'm talking about the conventional wisdom. Again, I'm not necessarily saying it has to be that way. I want to go back to Schedule 1, though, those second 2 factors, currently accepted medical use and treatment, because this also gets back to, we keep talking about the FDA process. It's not defined in the statute. There's been litigation over it. DEA wanted to say it was an FDA approval, and this was the Grinspoon case. The First Circuit said, no, that's not what it means. And then on remand, the DEA, there was more litigation, and ultimately DEA came out with a 5-factor test, which is fundamental. It's basically equivalent to what you need to get FDA approval. So it's not FDA approval. It's just like you have to show it's safe and efficacious, and scientists accept the drug. And by that point, you have to get FDA approval. And that's why common wisdom today says the only way to get out of Schedule 1 is to get something approved by the FDA. I don't think that statutory interpretation is right. I actually think it's not just wrong, but if you were to actually get it in front of a court, it's slam dunk wrong, because factor 3 is a lack of accepted safety for use. So it seems kind of impossible that both B and C are looking at safety for use. It's just not the way you write statutes. That doesn't mean the most effective way to get your product to market is to go about suing the DEA, but it is to say that there are aspects of this which aren't functioning the way they should. As a practical matter, though, and I think this is important, we focus a lot on the schedules, right? But you can't market medicine in this country without FDA approval anyway. So, if you're trying to develop pharmaceutical medicine, Schedule 1 is a problem, and I think we're going to get there. The reason Schedule 1 is a huge problem, but it's not because doctors can't prescribe it. It's because of other sort of reasons surrounding what it means to be a Schedule 1 drug.
Yeah, so why don't we just get there? I think it's not necessarily in the layperson's understanding or the sort of lawyer who's not focused on psychedelics, that you can conduct research on Schedule 1 substances. There's a way to do it. If the standard is no accepted medical use, there is a path to get to an accepted medical use. But what does that look like? First of all, how do you go about Schedule 1 research? And second of all, how do the sort of restrictions on it inhibit research as we'd like to see it just from a sort of pharmaceutical development perspective?
Right. So the research that gets a drug out of Schedule 1 into some other schedule, and, basically, if the drug is approved by the FDA, it has an accepted medical use and must be removed from Schedule 1. That's it's not a negotiable proposition. Once the FDA approves it, it has to get removed from Schedule 1. There are even timelines in the statute for how it's almost immediate now. How do you do that? Well, there are provisions in the Controlled Substances Act which allow people who hold Schedule 1 licenses. You put together a research protocol for an IND, an investigational new drug application with the FDA, and then you get approval from the FDA, and you go over to DEA and said, I got approved. Now, give me my Schedule 1 license so I can do some safety studies or some clinical trials or whatnot. And that's how you do it. It is, in some cases, it's not actually that huge of an obstacle. If you're a big pharma company and you've got a lot of capital, if you've got a regulatory affairs department and, if you're making billions of dollars a year in royalties on your other drugs, and, it's just a cost of doing business, right? Getting these permits can be a lot more difficult for startup companies, and it's been very difficult in the psychedelic space because it's not just you don't have huge regulatory affairs, but there are also other costs, right? I mean, this isn't just a licensure. You need to have a safe. Everyone on your team is going to have a Schedule 1. Like, there is a provision which says like your agents or whatnot, but moving Schedule 1 drugs around the country, you have to have what's called a Form 222 to move things between two places. That's a lot of friction that adds up. And it makes the research harder. And sometimes it actually, I would say, is completely prohibitive. The example is when you're not actually doing clinical trials with the Schedule 1 drug, but you're using the Schedule 1 to do clinical trials or other research with some other drug, which is quite common in the psychedelic industry because the effects of these drugs is not as linear, might not be the word, but predictable is perhaps the word. So you need to actually do a lot of assays and comparisons and whatnot. And when you start creating these regulatory barriers around the tools that you're able to use, you're really impeding the process of drug discovery, I think is what we're talking about, right? I mean, the moment you've gotten a drug to phase 2 or phase 3 trials, like Compass Pharmaceutical, for example, and you're well capitalized, is the Schedule 1 really that much of a barrier? Probably not. It's kind of getting that drug off the ground to 2, so you can basically get investors and tell them, hey, it's worth putting money into this thing because we know it works. If you don't get to that point, then it's that to me is kind of the that is the rub of Schedule 1 right now, is it's really kind of impeding us from making better molecules. Because as great as the promise of psychedelic medicine is, I mean, MDMA seems like in 2010, and that's what got me in part interested in this. I was like, wow, these are amazing results for drugs. They're still very imperfect medicines, right? Side effect profiles are not that great. The duration, man, the paradigm, the whole, like, someone's got to sit down for 6 to 8 hours and be with you. I mean, no MD wants to do that, right? So we need better molecules. And unfortunately, it doesn't look like policy and the law are allowing us to develop better molecules, or at least right now, not at this moment.
So better molecules is a great segue to my next question, which is, new drugs sometimes come onto the scene, new molecules are synthesized and all of that, and we'll get into the process for them actually getting formally scheduled and some of the DEA efforts in a minute. But there's also the Federal Analogue Act, to which these molecules may be subject, that's codified as a portion of the Controlled Substances Act, but was passed separately. Could you give us sort of a sense of how that works and why it's relevant?
Yeah, and I wrote fairly recently an article on the Analogue Act. I have a newsletter. It's ondrugs.substack.com, and I publish some stuff there. And if anyone wants to go read it, but the Analogue Act is actually imperfect legislation, and it's one of the areas that I actually have sympathy and defend the DEA and what it's doing because of. But basically, the Analogue Act was passed. There was a designer drug, quote unquote, epidemic. I don't like the word to use. I don't like using the word epidemic to describe these sort of flare-ups of drugs, but suffice to say, just to describe what's going on. And Congress decided we need to do something about it. Problem is amateur chemists were making analogs or structurally similar molecules to existing scheduled drugs, but of course, the schedules only list the exact chemical formulas. So in the case of MDMA, it's 3,4-methylene deoxymethamphetamine. It's not like some analog of MDMA, like MMDA, although I think MMDA might also be on MMDMA, but that might be on the schedules as well. But you get my point. Like it doesn't list every possible analog. And so, you tweak a molecule, you get something, it's not the same, obviously, but and sometimes, of course, and this is really important, like sometimes you tweak the molecule and you get something that isn't even psychoactive, right? I mean, the brain is so sensitive. Like the way we see molecules on paper is not the way the brain sees molecules in the body. You tweak something small and you could have something completely different. But Congress passed a law that says if something is structurally similar to an existing scheduled drug and it has similar pharmacological effects in the body, then you may treat that drug as if it were a Schedule I drug to the extent it's for human consumption. The concept behind this law is actually quite good, right? It's basically saying you can do research with the drug if it's not for human consumption. So it's kind of it's class-wide scheduling saying, we don't want these offshoots of Schedule I or Schedule II drugs out on the streets so that people can, basically circumvent the law. But we also want people to be able to research these drugs. Maybe they're useful. Maybe we want that. The problem is the way it's kind of plays out in practice is it's a criminal law. It's not quite regulatory. And to enforce it, you need to basically get an expert to show up to talk about how two molecules are the same, and you need to get expert testimony to get that the pharmacological effects are the same. It's effectively like at any point you want to enforce it, they need to basically do a scheduling action in a particular like criminal litigation by bringing down an expert. I'm not going to defend DEA on too many things, but I'll defend it here. I mean, it's an asinine like enforcement mechanism to have an in-house expert or experts travel across the country to like federal district courts and testify and whatnot. So, I've proposed ways to fix it, but let me bring this into even more contemporary relevance, right? I mean, we're having this big debate over fentanyl analogs, right? And if we actually had a working analog act, something that was written in a way where there was class-wide scheduling, but it permitted research as sort of like an exemption or like a defense or whatnot. If there was something that was better written, we wouldn't even be having this fentanyl analog debate because it would all be an analog. It would be class-wide. And, at the same time, a lot of the reason we have opponents to sort of class-wide scheduling and fentanyl analogs is because it would impede research into these drugs. So, and you could say the same thing about psychedelics, right? I mean, this would be, if the Analogue Act were a better written law, then the DEA wouldn't really need to schedule psychedelics because everyone loves research and people don't really, want people. Well, I don't personally care, nobody's hurting anyone, but you understand my point. I mean, the whole premise behind this is people aren't recreationally using. So if you can strike that balance, which the Analogue Act almost did, but missed on this one point, which is just, you've got a good law there. But right now it's not there. And I would love to see Congress fix that. But
maybe not the first thing on their list, if they get anything on their list done.
Yeah.
So say that the DEA actually does want to schedule a new compound, not just regulate on the Federal Analogue Act. Can you walk us through sort of the process the DEA proposes it, what the standards are, the rulemaking, kind of mechanically how a new substance winds up on, let's go with Schedule 1, but really any schedule?
Sure. I mean, it's going to be the same. Well, there are two there are three roads according to the statute. There's, on petition of the Secretary of HHS, the Attorney General, which is DEA, or any interested person. So anyone on today's listening to this podcast can petition the DEA to schedule or reschedule a drug. I've thought about it, actually. I've thought synthetic nicotine is actually an interesting case for something that has no accepted medical use and high potential for abuse. But I've got better things to do. But I also, well, anyway, so anyone can petition, but basically the way it usually works is one of two things happens. DEA identifies a drug of abuse in the community or something. So I think we're going to get to what I'm doing now with the 5-tryptamines in a moment, and I'll explain how that turned out. But that's one path. DEA identifies something. Another path is a pharmaceutical company is bringing a drug through the FDA process, and you have to do central nervous system studies. And any drug that has an effect on the CNS has to go to FDA's CDER. I forget exactly what it stands for, but it's like Center for Drug Evaluation Research or something like that. But in any case, if DEA identifies something, they send it to CDER. So it goes to CDER no matter what. And they do what's called an 8-factor analysis. It's 21 USC 811C. There are 8 factors in the CSA. The first one is actual or relative potential for abuse. And you go down the list and there's the pharmacology of the drug and then all those things are evaluated. There's a report that the Health and Human Services generates, and then they send it back to DEA. DEA looks at the report and they decide whether to schedule it or not. If they do decide to schedule it, then they have to put a notice in the Federal Register telling the public where they want to put it. The public can submit comments, and if you're an interested person, you can request what's called a formal rulemaking, which is this very arcane process where you present evidence to the DEA to basically say like your analysis is incomplete, wrong, or whatnot, and you can challenge the scheduling and say, you know what, I don't think this conclusion. And if you do that, you end up before an administrative law judge who takes the evidence and issues a recommendation for the DEA administrator. This formal rulemaking has occurred, I think, 3 times in history, other than the one I'm currently involved in. So this is, I think, the 4th, or no, maybe it's the 5th. I think there was the one. So I'm involved in one, and I think we're about to talk about it, involving 5-tryptamine substances. There was one in 2010. The name of the drug is escaping me. I think it was brand named Soma. Oh, it's Carisbrodol was 2010. I think there was a formal rulemaking, and then MDMA is obviously is one of the best known. And then I think Quaaludes back in early on or went through its scheduling. So it's not frequent. But and the other thing I would note is this 8-factor analysis. These factors are kind of redundant of each other. At the end of the day, the analysis is kind of like, is it approved by the FDA? Is it like any other drug in Schedule 1? If it is, it goes in Schedule 1. If it isn't, part of, and I think this is where we'll pivot to next, I think it's bad science, honestly. because it's not, look, if something was truly like a drug in Schedule 1, right? If two drugs are very similar, that seems fine. But the question is how do you know when two drugs are similar? And what the analysis they do is, drug discrimination, rat studies where they train rats to pull levers and whatnot. And that is established science. I think it is a tool. I think assays are tools too, what receptor activity, but the science that we had 10 years ago with psychedelics is very different from the science we're using today, thanks to this industry which is developing. And I don't think that our federal government right now has caught up to where the private industry is with this science. And I think that if we're criminalizing substances, perhaps it should. And I think that kind of segues into this tryptamine discussion, right?
Yeah, let's do that. So this is how Matt and I met. He's currently working on 5 tryptamines proposed rulemaking, and I'll just sort of give you an open mic on that. And I think that it would be helpful for people to understand sort of mechanically what these disputes look like procedurally, because they're a little bit unusual to what folks may be used to.
Right. No. And thanks again, Paul, for having me on so I can talk about this, because and with the caveat of this is kind of pending litigation, so there are things I can say, things I can't say. Is kind of unorthodox because it's a public proceeding without a publicly accessible record, although we're kind of working on that so people can follow along. The DEA in January proposed to put 5 tryptamine analogs into Schedule 1. One of them is a substance called DIPT, DIPT. It's I don't think anyone would ever suggest that it's like frequently abused, because it's kind of very unique as far as psychedelic. I mean, is it even a psychedelic? It has auditory hallucinations or whatnot. It is kind of it's the hallmark of the drug. Has activity on serotonin receptors. It's just kind of like out there, right? Nobody would ever suggest it's like anything else in Schedule 1, and yet that is the reason that it is getting placed there. I think they did drug discriminations with DIPT and DMT and concluded that they're alike. I mean, this is the science we're working with, right? It's like, I don't know. I mean, I don't think anybody who any credible scientist would actually contend that those two drugs are remotely similar. But in drug discrimination studies and you get same receptor activity. So DIPT is one of them. Another drug that there are 5 tryptamine analogs. We were talking about the Analogue Act, are analogs of scheduled substances. They're analogs of psilocybin. They're analogs of a lot of scheduled drugs because there are a lot of tryptamines in Schedule 1. Another drug, a notable one that's getting put on Schedule 1 is 4-hydroxy-DIPT, 4-HO-DIPT, or 4-OH-DIPT. The DEA and the chemists would actually call them differently, which is interesting. But that's a drug, interestingly, the prodrug of it that Field Trip is trying to put through the FDA process. So already, right, we're putting drugs on Schedule 1 that at least one company is, and they Field Trip submitted a comment to oppose it, although they have not shown up in the rulemaking yet to protest the decision. However, I should note that it's not over. That there's actually going to be another window for folks to participate in the rulemaking, because DEA is going to have to post a notice in the Federal Register inviting people to come. That hasn't happened yet, so there's going to be another 30-day window. But I mean, in any case, I represent 2 clients that are Tactogen Inc. and Mind State Design Labs, which are doing research with one or more of the tryptamines, and using and they're generally working with analogs as far as using AI to pin down on molecules that are promising. Mind State in particular is even trying to sort of map the psychedelic experience and whatnot. And so this is concerning on one level because it directly impacts those projects, but also on a secondary level. And I don't need to spend too much time on it, but the science that DEA is using to put these in Schedule 1 is or forget science, the logic is just it's atrocious. And the danger is what appears to be happening, at least appears to be happening from my vantage point, is DEA is becoming more active with psychedelics. They have hired the scientist named Dr. Teresa Carbonaro, who used to work with Mullen Griffiths and Matt Johnson at Johns Hopkins. She's been working there since 2018, but and she's a pharmacologist at DEA, and she knows her stuff because she's published on a number of papers. And in particular with this 5-tryptamines, I think the most objectionable aspect of this isn't the scheduling of it's not that they're being scheduled, it's how it's being done. And in particular, in this case, they're using an HHS evaluation that was rendered in 2012. So that loops back to a comment I said earlier, which is the science on this stuff has progressed so much from 2012. And the problem here, right, is if this is the record of what these drugs or drugs like them do, then the next drug that comes along, DEA is going to cite back to this saying, well, we determined back in this proceeding that this means this goes in Schedule 1, and therefore, and so it's this domino effect. And that's kind of, that's why we're kind of speaking up. Do I expect to succeed? Won't comment on that. I'll just say, we're going to try, we're going to do a good job. And if necessary, we'll take an appeal up to the Court of Appeals, and I'll get to litigate my own Grinspoon versus DEA.
That's great. And just to be clear, so sort of the opportunities to challenge here are, one, it's notice and comment rulemaking. There's a comment period, and comment period can be reopened. And then after that, it's sort of Administrative Procedure Act appeals, right? Challenging rulemaking, or how does it work?
Yeah, so there was a notice and comment period. That's closed. So you're not submitting written comments. That is I think there was 30 days in this case. Sometimes there's 60 days. I know the DOI, there was 60 days. That has to do with the statute and international treaties. But so there are 30 days for written comments, but because someone requested a hearing, it triggered some other regulation, which says that there has to be a notice in the Federal Register to allow other people to join the hearing if they're interested person. So there's going to be another window that reopens. But yes, if you could either submit notice, you could submit written comments, and then, technically you can appeal from if they don't address your comment. And then separate from that, there is kind of this in-person formal rulemaking. And again, we start at the agency with the ALJ, then we go to the DEA administrator, and if we don't get what we want there, and there's the sort of the will, we can you go straight to the Court of Appeals. There's no district court, no federal district court here. You go straight up to the Court of Appeals.
So, and I want to pick up on another thread here. I agree with you. It does seem like there's been increased activity from the DEA on psychedelic compounds. Some of it, at least seemingly to me, without any apparent uptick in the recreational use of what are fairly esoteric, rare compounds that are at issue. It's impossible to know. It could be, certainly the cannabis regulation has become a mess, and that must be a concern to them. But what's your take on why the DEA is moving here, particularly with some compounds that are a little bit odd? I live in Venice. I would imagine most psychedelics are people are actually interested in are available here in this place, right? And these compounds are not things that have any likelihood of becoming street drugs, as far as I can tell. So why?
Yeah, look, I can throw out reasons, and I certainly can put on my tinfoil hat and suggest that, Compass Pharmaceuticals drove down to the DEA and said, hey, if you put all these competing molecules in Schedule 1, it's going to make it easier for us to had to own the market on psilocybin when we get approved. I don't think that's what happened, honestly. But that might be the effect of what happens, to be clear. I just think that is almost impossible to believe. And I'm not saying that because I want people to believe it and saying it's impossible. I really don't think that's the case. I think that the more likely explanation here is DA might be running out of things to do. We have a drug industrial complex in this country. It's not just DEA, it's FDA. In fact, it's more so FDA than DEA. It's a huge drug industrial complex that we have the pharmaceutical industry, and we have FDA, and frankly, we have a bunch of lawyers, honestly. And it's this huge, honestly, incestuous, like people going back and forth and all sorts of stuff, and people with vested interests and not seeing things not change. And with the FDA, I mean, that's beyond the scope of this discussion. We have the fact that the FDA itself is funded by the pharma industry and whatnot, but the DEA is kind of like it's a slice of that, right? And so the DEA likes dealing with pharma companies. I don't blame them, right? I mean, and this is something that I think that lawyers in the industry, something I try to deliver to my clients, is I try to give them the professionalism that I would give to a client that isn't in the psychedelic space or isn't in the cannabis space. Same service that I would give any client in the energy industry, in like top professionalism, being punctual, all that stuff. Like, and a pharma company, right, is going to do all that. Like, they're going to dot all their I's, they're going to cross their T's, they're going to be great to work with regulators. And, I think for lack, I think it's not to blame anyone, but the industry's kind of, compared to that, it's a little amateurish, right? So DEA has this incentive, right, to not to prohibit psychedelics, but to basically kind of force it into the pharma box, because it's just kind of like easier to deal with, and it's predictable, and so on and so forth. And it's, again, I don't even know if there's anything entirely malicious about this. It's just kind of like the way, when you have this complex, it's like the way you think. It's like, yeah, of course, these psychedelics don't have accepted medical use. They're not approved by the FDA. So we're going to put it in Schedule 1. And you're going to force you to go deal with FDA like we do with every other drug. So, that's the thinking. And again, I don't know if there's anything completely malicious about it. I do think that they are still over there fighting the war on drugs, and they view the psychedelics as part of the war on drugs as opposed to part of the solution. They view it as, between problem and solution, they see it far closer to problem than solution. I think there's generally a lack of creativity in government, a lack of open-mindedness in government. So, all of these things mixed together. I don't think they're launching a war on psychedelics. That's not what I think is going on. But I also don't care. And the reason I don't care is I'm concerned with the effects of what's happening and the actions and what they do. It doesn't really matter to me why they're doing what they're doing. What really matters is, what are the effects of this, and what are they going to have on my clients? What are they going to have on the industry? And so, why they're doing it, it doesn't really matter to me. I think it's bad precedent, bad policy, and it's going to hurt a lot of people in ways that aren't going to be so like visible, right? It's kind of like it's going to hurt people without you actually seeing it. And that's the worst type of hurt.
I think that transitions to this question, which is, you've talked a little bit about the faults of the Federal Analogue Act, and we just mentioned a little bit the potential faults in the sort of DA's biases and how to view these compounds. What are the major pain points? What would you like to see changed in, I assume it'll be federal law, although state law is fine too, in regulation of psychedelics, if it were up to you, blue sky?
It's just get rid of Schedule 1. It's such a simple idea, but I didn't have time to discuss the schedules in depth and detail, but interestingly, the regulatory restrictions between Schedule 1 and Schedule 2 drugs are nearly identical, down to needing a safe and quotas and whatnot. The differences, however, are both small but consequential, and lead to all the difficulties we were talking about before, of needing permission on a per drug basis, and only being allowed for research and whatnot. I mean, they're small, but the important thing actually is that a Schedule 2 drug and a Schedule 1 drug, DEA can impose quotas. So this whole medical use thing is almost it was included in the Controlled Substances Act in 1970 for administrative efficiency, among other things, but it's almost it's like an appendix in a sense of, the act has progressed, and FDA we've progressed to the point where currently accepted medical use means FDA approval, but you can't go around marketing non-FDA approved drugs anyway. So no one's going to be out there, PCP, like, no, it's in Schedule 2. No one's out there legally selling PCP for a variety of reasons. So, so this idea that we need that. The other thing is they can set quotas to 0. If something doesn't have an accepted medical use, DEA can just simply, or not 0, but like, only 100 grams can be made of a particular thing just for research, right? And so you have a quota, and so it's not circulating. And so this whole schedule, like, I don't, is this ever going to happen? Like, I don't think so. But like, if you actually look at this and think about it rationally, like LSD doesn't need to be in Schedule 1. It can be in Schedule 2. No one's going to be prescribing it because it's not approved by the FDA. The quota is not going to be like, 15,000 mics or whatever, like, or maybe that's not that much, but like, the point being, like, it's not like the sky is going to fall, and yet we think it would be. But that's because a lot of people actually, policymakers, have never actually looked at this law. They've never actually like sat down and like looked at the law. It's just, we kind of take it for granted. But it gets back to the, nobody's thinking creatively about solutions. It's kind of status quo and frankly paranoia, right? I mean, it's and that's another thing about psychedelics, right? It's an educational exercise. And again, I always tell, I think I was interviewed in some publication at some point about kind of like, how am I able to do what I do in my law firm? And I basically say other people. Like, there was years worth of work by other companies and nonprofits such as MAPS, USANA, and a bunch of nonprofits working with vets, and like your company as well, people who are legitimizing an industry with medicalization, science, and research, which is allowing legal professionals to climb into the space, because there was and there still is some stigma, but it's the work of other people which is kind of reducing that stigma. And we need to keep doing that to kind of soften lawmakers and policymakers and stuff. We're just working at the state level, and now we need to move to the federal level.
That's helpful. So where do you, following up on that, see the field in 25 years or so? At the moment, it's dominated by pharma, and the emphasis just in getting to market is on sort of modifications of known compounds for psychiatric indications, polymorphs and things like that. Is that the bulk of the story in 25 years? Is it just decriminalized and all over the place with psilocybin? Is it sort of analog molecules that we can't imagine today that are loosely inspired by the original compounds that are actually for heart disease? What do you think the psychedelic research, or at least the psychedelics field, looks like in 25 years? Yeah,
it's a hodgepodge of that stuff. I'll say that I'm not as, I don't think it gets as far as some people think it's going to roll. And again, I don't like pointing to cannabis, but there's a talk, one of the views in psychedelics, right, is legalization follows medicalization, right? Well, got bad news for everyone. Cannabis was medicalized or whatever starting in the late 90s. And here we are 30 years later, and legalization looks like it's still not around the corner, right? So you asked 25 years, that's why I just brought this up, which is 25 years ago, people were saying, hey, let's get the ball moving. 25 years, we're going to have legalization. And we're not there with cannabis. Again, the legal issues are different. There's the status quo in cannabis isn't going to hold in psychedelics, but I think it's kind of just instructive to say things a lot of times take longer than you think they would. And I think that's going to be the case with psychedelics. I do think MDMA and psilocybin are going to get approved by the FDA probably in the next 5 years, is what I would say. I don't know. I don't think it's next year. I don't think it's the year after, but it's somewhere there. I think more importantly, there's going to kind of be like limited rollouts. The expanded access is actually kind of moving a little bit now in that department. The beauty of psychedelic medicine that's different from something like cannabis, and the hope for it being faster and accelerating, right, is at its best, it's transformative. And that's, there's an article about Rick Perry. It's like, I think the title is called Rick Perry Drug Pusher, but it talks about how a veteran was like living with him and, did psychedelic therapy and just, changed his life. So it's not just the individuals who are transformed, but the people around them. And cannabis, no doubt, helps a lot of people where opiates don't help. But it's not this like it's some people think it's a psychedelic too, but it's not like transformative, right? And so that's one thing psychedelics have for it. But I don't think that favors legalization, honestly. I mean, they're transformative because they're these powerful tools. And so I think that means that we are going to be proceeding with caution. And I think caution is going to basically mean that we're not going to ever get to this like full like legalization state. And maybe we shouldn't, and maybe we don't need to is the other thing, right? I mean, I think that we need to be focused on things like equitable access so that people can get it. Certainly, like, insurance, we need to be conscious of that. A big reason I love companies like yours and people working on second generation molecules is, again, the first generation stuff is good, but the whole like therapist for 6 to 8 hours, insurance, that's going to be like mighty insurance costs and everything. So better stuff. So what I see is a hodgepodge, right? Where in essence, the imperfect psychedelics, there's never going to be perfect, but the ones that are being working on now, honestly, aren't really that conducive for legalization. But the next generation might actually be kind of, it'd be a little bit more interesting, right? Something that's a little bit shorter acting that you don't need specialized training for. Maybe you just can go see like a generalized therapist. Maybe it's, over the counter, like a dextromethorphan cough syrup type thing, which is you can totally trip on it, but sold over the counter, right? I mean, I think there's a future there where milder psychedelics maybe are completely legal, but I don't think in 25 years we're living in a world where the Controlled Substances Act goes away. Like, no way, no how.
Serious question. This is, after all, a bar association. There are lots of folks who are interested in psychedelics and in doing something in the field. In going around looking for interviewees, there aren't that many folks who are actually day-to-day doing legal work in psychedelics, at least from a litigation perspective. Plenty of patent lawyers, general counsels, things like that. For lawyers interested in working in the psychedelic space, where would you tell them the work would be today? And I can use 25 years again, maybe that's a bad time frame, but where do you see the work being for folks who do want to get into this?
Yeah, I mean, that's a great question. And I think the first thing I would point out, right, is I'm doing like federal stuff. And I do think federal is important because of the Controlled Substances Act, and it kind of predominates. But there's going to be state level initiatives. So, I mean, you said litigation, but let me kind of step aside from that, right? We have state level decrim initiative, like legislative stuff, like writing new laws and lobbying and whatnot. A lot of, so that's kind of like, I would say is, but that's like low hanging fruit. Let's kind of be like a little more difficult, right? Like you want to be a litigator and you want to like litigate psychedelic issues. I mean, to some extent, right? It's not so much an area of law, it's an industry that's going to have ordinary legal problems. So it's about networking with companies that are going to have those problems. And then it's kind of, I think, and this is kind of how I got to be where I'm at, it's being and not to try to toot my own horn here, but I didn't wake up with all this knowledge that I just poured out. Like, I've actually spent a lot of time like reading things and like the law and like the Federal Register, and like I have read a lot about this. I don't pretend, well, maybe not, I haven't read the most of any lawyer, but if I haven't read the most of any lawyer on this stuff, I'm probably in the top 1% and maybe the top 0.1%. So sitting down and reading all this stuff, because then the next step is foreseeing the issue that's about to come, the issue around the corner, because the companies now are very focused on patents, right? That's probably the biggest focus in the psychedelic industry of companies is patent acquisitions. There are other things. I'm not pretending that's like the sole thing. There's also like the regulatory sort of the getting the permits and whatnot. But if you're thinking about litigation, right, like what are the issues going to be? I mean, I can float some out there. Like there might be antitrust issues, right? There might be anti-competitive issues because of the way psychedelic therapy is structured, where, can you require someone to use your therapy with your drug. I mean, that's a tying issue. So writing about those issues, right? Because then when a company has these problems, or a company has a problem with another company that's doing this, or frankly, just even an ordinary consumer has a problem with it. And you're the one person who's thought about this in detail and has fleshed out the arguments. You're going to be the person who gets the phone call. And then the other thing is, like, again, just kind of meeting the companies and whatnot, because again, they're going to have ordinary legal problems. I mean, I'm a trial lawyer first. I do commercial litigation. I can try a breach of contract case. I wouldn't do an ERISA case. I would refer that to someone. I wouldn't do a California state law case. I'd probably refer it out. I mean, that's my final point, right? Is know your core competencies and send work to other people. I've gotten work from other people, but I also send work to other people because I just don't do that stuff or don't want to. But that's it's a good way to, it's about really, I mean, it's in some senses, and look, I just made partner here, so I'm not the guy to sort of lecture other people about business, but in some senses, it's really not that different from any other type. Just build your network, build a particular niche expertise, and see the problems before they happen.
Great. And I will end with a bonus human interest question that I ask everyone. Do you have a favorite fictionalized depiction of psychedelics in a movie, book, whatever else?
Yeah, I mean, Fear and Loathing in Las Vegas is like a cliche answer. I mean, I would say that this isn't fictionalized; it's totally real. But Doors of Perception is one of my favorite books of all time. That I read in that sort of period where I took the drugs law and policy class. But that's not fictionalized, but it's certainly a work that I think hasn't really been surpassed in terms of its raw, like, capture of the psychedelic experience.
I thought I was going to get Fear and Loathing just straight down the line every time I asked this question, but you're actually the first to use it. We've gotten The Matrix and some other interesting stuff.
Oh yeah, no, I would think that you would. I mean, it seems when you drop the word fictionalized in there, it's like, oh, I gotta. It's not, psychedelic experiences aren't really. I mean, they're portrayed enough. I mean, actually, what's another interesting one? The Sopranos, when Tony has the mushrooms. I actually think I get a fucking, like, and that's in Las Vegas too, but that's a fucking hoot, because it's like Tony Soprano tripping is like just kind of.
All right, great. Well, we're out of time. Thank you very much for this. It was extremely informative. It's a real mic drop to be actually citing statutory provisions by number and everything. And the cool part is that your passion for the subject came through while you were doing that, which is a hard thing to pair together. So this was very interesting. And I'm sorry we're out of time, but we really appreciate it.
All right. Thanks, Paul.
Thank you very much. Bye.